One of employers' quote-unquote favored ways of getting rid of older workers and discriminating against employees because of their age is classifying a termination of an older worker as a layoff and using it as a disguise for a wrongful termination and disability discrimination. So, an employer would come to the older worker and would say, hey, we have to lay you off because of restructuring or reorganization or cost cutting or because we're shutting down this department, when the real reason is actually that employee's age. So how can you determine whether a particular layoff is a genuine reduction in force, which is legal, versus age discrimination and wrongful termination? There are a couple of key things that you should look at initially to determine whether there is something there, whether there is a possibility of a legal violation and age discrimination there. The first and the most obvious key piece of evidence that you should look at is whether or not the employer is looking to hire someone to replace you, or whether they already hired someone to replace you into the same position or a position that has a slightly different title but with essentially the same duties. What employers often do, the sneaky ones, is that they would quote-unquote lay off one older worker, then they would wait for a couple of weeks or maybe a month, and then they will start posting the same position on Monster, on LinkedIn, on Craigslist, or elsewhere. Now, of course, if you sign a release and settlement agreement and you take severance early on, what you find out later about the company's hiring is irrelevant. But if you're not in that situation, if you don't sign any releases upon your alleged layoff, then you should consider looking into whether or not the company is hiring or is planning to hire someone in your place. Although lying about laying you off alone does not prove discrimination, it's a good start. It means that it's worth looking into the situation deeper and seeing if you can find other evidence that the true reason for your termination was your age and it was not a real layoff. So again, the first piece of evidence is if you're terminated and if you don't sign a release, you or your attorney should look into whether the company is advertising for your position. If they do, it means it's not a layoff, they're not telling the truth, there might be something more there. The second simple piece of evidence that you should be looking into is whether or not the company actually hired someone to replace you. And not only did they hire someone to replace you, but they hired somebody much younger. So generally you need the difference of you being over 40 and the new employee under 40, but that's not the only way to show age discrimination. In fact, the law says that one of the elements of age discrimination claim is showing that the employee who was hired to replace you is significantly younger. And that's where the confusion often happens. Some people think that you have to show that you were over 40 and the other person was under 40. That's one way, but that's not necessarily the whole story. The standard is you have to be over 40 and the person who replaced you has to be significantly younger. So this could be 68 and 50. Both of you are over 40, but you have 18-year age difference, and that's a significant difference, and that qualifies as a significant difference enough for the purposes of proving age discrimination. Now, if you're under 40, let's say if you're 38 and they hire someone who is 20 years old in your position, then you don't have a case as a matter of law because you're not in a protected class. At least as of today in California, if you're under 40, you're not in a protected class. And the third key type of evidence that you should be looking out for in order to make an age discrimination claim is talking to your former coworkers or even former managers and seeing if they have any emails, text messages, LinkedIn messages, Facebook messages, or maybe they themselves heard the decision makers say anything that would suggest that the true reason for your termination or one reason for your termination is your age. So these statements or emails or text messages could say something like, we need someone with a more youthful outlook, or this employee's views or his work is outdated, his views are outdated, his strategy is old school. We need someone quicker, we need fresh blood, we need someone younger. Anything that suggests that they were unhappy about your age in so many words. So, if you have one or more of those types of evidence present in your layoff, it might be worth looking into whether or not the true reason for your termination was your age, and you at least have an option of making an age discrimination and wrongful termination case. Thank you.